Mr. Smith, in cause number 25 BCCR 1251, you're charged with the state jail felony offense of theft with previous theft convictions from August 14th of 2025. The indictment alleges you were previously convicted of theft July 29th of 2014, and then after that, December 16th of 2014. And how do you plead to that charge? And are those prior convictions true? Are the prior convictions true?
Yeah.
And did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Adams?
Yes.
Do you fully understand them?
Yes, ma'am.
And just like that, we shift from routine docket management to a case the prosecution clearly has circled in red. Watch what happens here. The state isn't talking about evidence yet. They're talking about witnesses. In criminal trials, witnesses can make or break a case, and when prosecutors start urgently asking for specific people by name, that's usually a sign those witnesses are absolutely critical to what comes next.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached,
2 years probated fine with $1,000 judge.
okay, y'all filled out the 2 years state jail and 2 years county jail.
Yeah,
State-
I couldn't erase it I was going to erase the county jail. I'm not sure which is
Okay.
but
All right, so it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine to follow all of the rules and conditions of probation, including being on the mental health caseload. So we'll give you everything you need in order to be successful. Is that your understanding?
Yes.
Do you also, and it looks like also that the state's going to dismiss a misdemeanor harassment charge in cause number 25 CCCR 1, is that a 1 or a 7?
it's 1688.
Thank you. 1688. It's your understanding that's going to be dismissed. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Mr. Smith, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and that you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. Do I need a pre-sentence report? Is there?
Please, Judge.
Okay.
I think with
So-
the mental health issues.
Yeah, he's going to have some special issues.
Sure. So I'm going to reset. I'm going to reset your case so that the probation department can do a pre-sentence report.
So this may seem like a simple warning, but legally it's a big deal. A subpoena isn't a suggestion, it's a court order. The judge is making sure this witness understands the stakes before trial begins. And notice the extra emphasis on the juvenile witnesses. That tells us the testimony of those young witnesses could play an important role when this aggravated assault case finally reaches a jury.
That'll just give me more information about you, your case, your history, what all you might need while you're on probation, and then we'll come back later for sentencing. Okay? All right, we'll see y'all at sentencing. Is the Ms. Coffin? You've got Jesse Griffin. Good morning. It's a very pretty suit. Good morning. Good morning, sir. You're Jesse Griffin. And this is cause number 25 DCCR 1397. Mr. Griffin is charged with aggravated assault with a deadly weapon. I'm going to take judicial notice of the court's file. Looks like Mr. Griffin was evaluated for competency to stand trial. Received that report from Dr. Papon dated April 15th of 2026 with the finding that Mr. Griffin is currently competent to stand trial. Any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
All right, then I am going to find at this time Mr. Griffin is competent to stand trial. And what is the announcement?
No.
Yes.
Now, here's one of the most important moments viewers often misunderstand. The defendant has already pleaded guilty, but sentencing isn't always about immediate prison time. What the judge is about to explain is a classic example of a high-risk, high-reward legal outcome. The question is, will he see probation as an opportunity or a trap waiting to snap shut if he slips up?
Your Honor, he still would like to proceed to a jury trial.
All right, so it looks like there was a plea bargain rejection in January where the offer was for 8 years. Is there any change in that offer or negotiations?
No, Your Honor.
So, Mr. Griffin, you still want to reject that and have your case set for trial?
Yes, ma'am.
All right, we'll get you moved to the trial docket. Ms. Coffin will begin preparation for trial. I do want to make sure you understand that after today, I will not accept this plea agreement unless some new information that comes to light that the attorneys don't know. If you change your mind later, want to enter a plea of guilty, it could be open to the court or to some different plea agreement, but not this. You understand?
Yes, ma'am.
All right, you can go back with the bailiff.
Thank you, Your Honor.
Your Honor,
Yes, ma'am. See, is there a Miss Bosley here? Okay.
So that's a massive break. Instead of walking away with a felony conviction today, he's being handed a chance to earn a dismissal down the road. But don't mistake probation for freedom. For the next decade, every decision matters. One violation could bring him right back into this courtroom facing years behind bars. The pressure doesn't end here. It actually starts here.
Mr. Parker, you've got Terrence Alexander.
Terrence Alexander. You gonna go on us?
Good morning, sir. Are you Terrence Alexander? And will your client waive the formal reading of the indictment?
You will, Your Honor.
We're going on count one only. Mr. Alexander, in cause number 22-40966, the state has elected to proceed on count one only. It alleges that you committed the state jail felony offense of criminal mischief from July 21st of 2022. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand that? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent, you understand the nature and the consequences of your plea.
Listen carefully to how methodical this process is. The judge isn't just accepting a guilty plea, she's building a record. Every question serves a purpose. Was the plea voluntary? Does the defendant understand the consequences? Was he competent to make the decision? These details may sound repetitive, but they're designed to protect the integrity of the conviction and reduce future challenges.
Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of criminal mischief. Sentence you in accordance with that agreement that you made to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You go back with the bailiff.
Can I get a paper that shows like my back time?
They're going to have to figure that out after court, and it'll be in your judgment and sent over to the jail probably this afternoon or tomorrow.
You know, I've already.
I just said you get all your credit that you're legally entitled to. All right, thank you. Victor Perez, Mr. Parker.
Pleading out for bill number 2.
Will Banning count to your honor?
Good morning, sir. Are you Victor Perez?
Yes, ma'am.
And Mr. Parker, will your client waive a formal reading of the motion?
It will.
Mr. Perez, in cause number 17-26788, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 8th of 2018 for the third-degree felony offense of assault on a public servant. And that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation in count 1 by committing the new offense of driving while intoxicated November 22nd, 2025 in Hidalgo County, Texas. And is that true or not true?
True.
And then the state's going to abandon 2, correct?
Yes, Your Honor.
Count 3 alleges that you were at a location other than your residence November 22nd of 2025 at approximately 2:08 a.m. And is that true or not true?
True.
Count 4 alleges that you failed to report for the administrative hearing on October 6th of 2025. And is that true or not true?
True.
Count 5 alleges that you failed to report by mail or online to the Jefferson County Probation Department for February, March, May, June, August, September, October, November, and December of 2022, January through December of 2023, January, March, June, July, August, September, October, and December of 2024, and then January through December of 2025. And is that true or not true?
True.
We can drop their many counts. Your Honor.
All right, sir, did you enter your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes.
Do you fully understand that?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
State tenders number 1.
No objection.
And here comes the crossroads moment. The prosecution has laid out the offer. The judge has made sure the defendant understands it. Trial is approaching fast. What's fascinating is that the state is emphasizing this offer isn't because their case is weak. It's because they believe the time already served may be enough. So now the question becomes, do you take the certainty of the deal or gamble on a jury's verdict? What would you do in this situation?
It's admitted. Is there any evidence that Mr. Perez is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of the lesser offense of the third-degree felony assault on a public servant. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff.